SJC-11911 in the matter of GP.
May it please the Court, Anne Grant for Appellant GP. I'm joined today by my co-counsel, Bob Weber. I'd like to start with the root of appeal to demonstrate that this Court is procedurally able to address all of the substantive issues in this case. A 211.3 is proper when there is no expressly provided alternative. That expressly provided alternative must be an effective alternative, meaning that if a substantive right is at issue, that right won't be lost if the typical route of appeal is pursued.
What's wrong with the appeals court? What's wrong with an appeal to the appeals court?
The problem with the appeal to the appeals court is that we would have to go on faith that the appeals court would not only render a final decision as opposed to sending it back down to a lower court for further hearing, but also exercise its discretion to hear it immediately. In that way, I'm pointing this court to its decisions in Planned Parenthood League v. Operation Rescue, 406 Mass 701, and other cases that have to do with the meaning of an effective alternative.
Where do appeals go now from commitments under Chapter 123, is it 123, Section 8?
Section 8, they go to the appellate division under 9A.
And then where do they go?
They go to the appeals court
Why
after that.
why isn't that as good a route?
Because where my client's constitutional rights were violated by this unconstitutional commitment order, she would not be restored to the status quo by pursuing a route of appeal where we couldn't be guaranteed a final decision.
Are you saying in your case or generally going forward? I'm not clear. Are you making an argument that every person in going forward next year, every person in your client's position would have a right to bring a 211.3 petition, or are you saying in this particular case we should decide it?
I'm saying that in this particular case, GP was procedurally proper in being before the single justice on a 211.3. Should this court decide that the appeals court is the proper route for other appeals in the future, where the appeals court is authorized to exercise its discretion to hear the appeal immediately and can render a final decision, that's fine. The issue is, was it procedurally proper for her to be in front of the single justice in this case? And that's where I would argue that the answer is yes, because that was the only effective alternative of appeal for her. And in fact, the Attorney General cites not one case where the appeals court rendered a final decision on a commitment order. Instead, the Attorney General cites 231-108, which is the law governing the appellate division and its power to vacate, modify, and reverse trial court orders.
I thought the Attorney General was speaking about going forward. I mean, in other words, what should be the standard with Section 35 cases in the future?
Yes, and actually in that regard, we agree with the Attorney General that the appellate division operated just as it should for GP in this case. It was merely the question of where to go after that for GP.
If we can focus on the merits.
Yeah.
now.
Yes, Your Honor.
Section 35 hearings are somewhat unique, prosecuted by laypersons, generally relatives, needing to be disposed of on the very same day that they come into court, even if they come into court at 4 o'clock. Is it appropriate for us to impose a proof beyond a reasonable doubt standard given those circumstances? Absolutely,
Your Honor. And the reason for that is that the burden of proof, contrary to what the Attorney General argues, is not actually on the layperson petitioner. It's on the clinician. And how do I know that? I know that because the petitioner has no ability to withdraw the petition after it's filed, which is unlike any other type of civil order. So, for example, when somebody's seeking a restraining order, they have the ability to withdraw that restraining order, and the judge has to comply with that and respect that decision. As far as, in addition, the judge cannot order commitment if the clinician argues against it. So that would indicate that de facto the burden of proof is actually on the clinician in this case, which brings us to really is what's the big balancing of interests in a Section 35? I would argue it's between the state's interest in committing somebody who meets the statutory criteria and the respondent's interest in liberty. The petitioner has no right at stake in a Section 35. which is why they don't get a lawyer. But the state's interest is properly protected in this context because the clinician bears the burden of proof, and there's a neutral fact finder to adjudicate whether they've met that burden going forward. In addition, I do understand the Attorney General to be arguing by talking about the opioid crisis in Massachusetts that that Section 35 hearings may present a special situation as opposed to 7 or 8. We argue that there is nothing which prevents the legislature from creating an emergency hearing for substance abuse disorder, like Section 12. So currently we have Section 12, which operates as an emergency hearing for anybody who's adjudicated mentally ill and poses a likelihood of dangerous harm, followed by a 7 or 8 commitment order, which poses the same kind of burden on the respondent's fundamental right to liberty that a Section 35 does. And that's why this court should not be imposing the less...
There's a significant potential difference between the burden on the liberty in a Section 35 and a Section 7 or 8.
I disagree, Your Honor, and the reason
90 days and the average time is 19 days? I mean, as opposed to 6 months, a year for a long, long, long time?
Yes, Your Honor, I disagree with that because despite the fact that the average length of time may be 19 days, the right that the respondent loses is for up to 90 days, and then it's at the discretion of the facility to release them before then, which is exactly how 7 and 8 works.
But you can't reapply, right?
Well, they don't have an automatic ability to reapply like they do with 7 and 8, but they can certainly seek another commitment if they choose to go into the same process.
Yes, but it isn't automatic. I mean, in other words, the person has to be released after 90 days, correct?
They have to be released after 90 days, but the same is also true.
At 30, 45, 60, 75.
It's at the discretion of the facility whether they're going to release the person at the time. They don't have a hearing with counsel and with a burden of proof and the rules of evidence. For 7 and 8, each of those additional commitments is after a hearing where the burden of proof is beyond a reasonable doubt, the full rules of evidence apply, and the respondent is represented by counsel.
But am I correct that it's 6 months and then every year that you?
Yes, it's 6 months for the first one, and then if they seek additionally to hold them again, they have another hearing, and that one's good for a year. But our argument is that the difference between 90 days and 6 months it really falls away when you look at what the direct and collateral consequences are that are imposed on the person being committed.
Do we have any information as to like what number or what percentage of people who are committed under Section 35 are employed at the time of commitment?
I don't have any statistics on that, Your Honor. I'd also like to...
Before we leave this point, in most commitment proceedings, same issue at some level is being addressed, danger to oneself or to others.
Right.
But in a Section 35 proceeding, generally the greatest danger to oneself is through overdose. Does that change anything with regard to what's the appropriate standard given the inherent uncertainty of whether a heroin user who is truly sort of out of control will kill him or herself with an overdose?
It doesn't, in that the statute doesn't allow for the commitment of somebody simply because they have an addiction to heroin. If there is evidence showing that they are likely to overdose, with some kind of evidence that would go to that point that they do pose a serious danger to themselves, then perhaps we'd get over the burden. But in some of these cases, for example, my own client's case, where there was really no non-hearsay evidence that was any articulable facts to support it, any corroborating evidence, you have somebody who's being committed because they're essentially a drug addict, and that's not what the statute allows for. So my argument in saying that the legislature has the ability to create a Section 12 hearing is to go to precisely what you're raising, Your Honor, which is that there is a situation where somebody who may be a lesser burden of proof or rules of evidence may be appropriate for a much shorter temporary commitment. But where this is a final adjudication of the person's liberty for up to 90 days, we're actually talking about 7 and 8 style of commitment, which is final and which requires the burden of proof of beyond a reasonable doubt and the full application of the rules of evidence. This takes me to how we can differentiate really all of the other hearings that the Attorney General argues that should be used as guidance. If the right to liberty is not at stake, it's not something that should be used as guidance for Section 35. This will take away arguments that termination of parental rights hearings or restraining order hearings are somehow analogous, because at the end of the day, no one's going to be committed or detained as a result of that hearing. The second point is that the hearing is not a final adjudication of the person's liberty. This is how we differentiate or distinguish Section 35 from 58A hearings, 57 bail hearings, and even 123.15 criminal competency hearings. In each of those hearings, the individual in question is a criminal defendant who, at some point, will be getting a trial with the full panoply of constitutional protections.
But at the point that somebody is incarcerated under 58A, he or she is presumed to be innocent. There is nothing about that that suggests there's guilt of anything. So why is that so different?
Well, this court has found that because it's one step before the final adjudication, that it makes a substantive difference in that whether that person is getting the constitutional protections to which they're entitled. The difference between
But
somebody...
in terms of the taking away the liberty for
90 days.
90 days, it seems to me I don't see the difference.
Well, I think a criminal defendant who was convicted and sentenced to a 90-day sentence would argue that, look, this is a final adjudication of my liberty.
Yes, but we're talking about a 58A.
Right, in 58A, that's a preliminary pretrial detention, and that's why it's treated differently than Section 35, which is a final adjudication of those 90 days. So the idea that this is temporary only goes to this person will be eventually released. Temporary versus final in the legal sense makes a difference here, because 58A is not a final adjudication of that person's
Well,
rights.
it's a final adjudication that they're too dangerous to be released and therefore need to be held pending trial. I mean, that's a final adjudication.
Well, it's not a final adjudication of their guilt or innocence. It's not a final adjudication
not
of
at
whether
issue.
they should be. Right, but it is pre-trial. And this court has found in Mendoza and even Querubin, which is cited by the Attorney General, that the difference between Section 58A and other types of hearings is that it's not the main event. And if that language is to have any meaning, what it means is that a trial makes a difference, because the criminal defendant will eventually get all the protection they're entitled to.
But will lose 90 days of liberty prior to any adjudication of the guilt or innocence.
Yes, that's true.
Liberty is at stake, 90 days, same block of time. There's no requirement for treatment or anything else, as there might be under Section 35. I don't understand how that's so different.
Well, it makes a difference as far as what the consequences going forward are for that person. If somebody is held on a 58A and eventually acquitted or not, they null pros or whatever the reason is, the fact that they were held on a 58A is not going to be used against them. That's unlike what happens in a Section 35, where an individual can get committed under Section 35, and frequently that adjudication of their liberty for that 90-day period, which said that they met this dangerousness prong and that they're a substance abuser, is used against them in later adjudications of their liberty under the same statute, which is why it's important to note this difference in how the two actually operate.
How would that work? Somebody's been committed under Section 35 5 years ago, and they come back today, and the judge looks at the prior commitment and decides that it has some relevance to the person's dangerousness to himself or others today?
Yes, that's what happens sometimes. In fact, a lot of times clinicians will testify that this person meets the definition, and something which mitigates in favor of that is that they've been committed under this section before. So it makes a significant difference to the person who has no notice that this hearing is going to happen, is often put in handcuffs, brought to court, put in lockup, and then brought up and is expected to face a hearing where she could lose her liberty for 90 days. It makes a huge difference that that hearing have constitutional protections like that is what is
Well,
afforded
it
for
does have
7 and 8.
constitutional protections. There's no question about it. The question is whether the extent of those protections. And proof beyond a reasonable doubt is the most extraordinary protection we can offer.
Right, and I would argue that due process requires that where you're losing your liberty for 90 days, and that is a final adjudication of that time
Certainly
period.
not due process under the federal constitution. You're talking under the state constitution.
No, that's right. This is where, for what it's worth, Massachusetts gets it right, as opposed to the federal government, the federal Supreme Court. The case that you're referring to, in fact, Addington, that also is about civil commitments under the mental health law, which this court has found to require, beyond a reasonable doubt, and the formal application of the rules of evidence. So this court gets that right for mental health commitments.
And to get that right means we can also distinguish that situation from this situation.
Right, and I would
without
argue
violating any federal due process principles.
that's true, and I would argue that this court should consider the fact that the legislature has the ability to create the hearing that I believe the Attorney General is really arguing for, which is an emergency hearing that will address the fact that some substance abusers pose this imminent risk without bringing with it the final adjudication of those 90 days and all of the direct and collateral consequences which are attendant on losing your liberty for 90 days. And for those reasons, beyond a reasonable doubt and the formal rules of evidence should apply. And I see that I'm almost out of time, but I do want to say that I argue, and I continue to argue that my client, whatever we use is beyond a reasonable doubt or clear and convincing evidence, whether we employ the rules of evidence or we use the 58A substantially reliable evidence, no matter what we use, she should not have been committed because she was committed because she wasn't able to get clean on her own.
Where is she now?
She has been released, but during the pendency of this case, at the different levels, she was still subject to the commitment order.
Okay, thank you.
Thank you.
Good morning, Your Honors, and may it please the Court, Assistant Attorney General Julia Kobik for the District Court. The legislature authorized civil commitment under Section 35 to help persons with substance use disorder and alcoholism along the path to treatment and to ensure the safety of those persons and their community. This court recently approved and promulgated a set of rules that will bring more uniformity and clarity to Section 35 proceedings. Those rules should be upheld. They afford multiple protections to the Section 35 respondents whose liberty is at stake, and they also promote the Commonwealth's important interests in protecting the respondents and also providing care to those persons.
Before we get there, am I correct that regardless of what we do in the future with regard to whether these cases go to the appeals court or go to us, you have no objection to our deciding this case?
We have no objection because this case was reserved and reported that this court can, we agree the court can decide the case. I'd like to turn to Rule 6A, which adopts the clear and convincing evidence standard of proof. This court has made clear on multiple occasions that beyond a reasonable doubt is not required for all civil commitment proceedings. The standard must be met when the potential length of commitment is indefinite or potentially lifelong. But when the potential length of commitment is temporary or limited, as it is with Section 35, proof beyond a reasonable doubt is not required. So this court has made clear that civil commitment under Chapter 123, Section 12, and Section 15B does not require proof beyond a reasonable doubt, and also pretrial detention on dangerousness grounds under Section 58A.
But what do you say, though, to the argument, putting the number of days aside for 1 minute? This is a final adjudication. It has so it is the main event. It has a wide variety of collateral consequences that may not be true of some of these others. I don't know.
Yes, Your Honor, I think you were exactly right on this point, and Justice Cordy as well, that under Section 58A, there's an initial adjudication that affects the defendant's liberty, and that issue is whether the defendant should be detained on dangerousness grounds. Subsequently, there's a criminal trial, and that deals with a separate issue. That's whether the defendant committed the crime. There's never a final adjudication on dangerousness for the defendant. That issue is decided under a clear and convincing evidence standard in the first instance in the dangerousness hearing, and then never addressed again. So I don't think that there is a subsequent main event under Section 58A. The other point I'd like to make is there's no main event under Section 12 commitments either. That there might be if a person is detained under Section 12E and then a Section 7 or 8 petition is filed, but the treatment facility does not necessarily have to file a petition under Section 7 and 8, excuse me. It might be that someone's committed temporarily under Section 12 and then simply is released, and then there's no subsequent main event in that case.
So is your argument that there really is a continuum and 90 days is on one, I mean, it's not that you're saying anything that's short of potentially life
Yes.
is, can use something other than proof beyond a reasonable doubt.
Yes.
But it is a continuum, and in your view and the district court's view, 90 days is more like Section 12 and Section 15B than Section 7 or 8.
Yes, I don't think that the potential length of commitment must be lifetime in order for proof beyond a reasonable doubt to attach, but it must be a very significant period of time. And so under Section 7 and 8, this court has characterized those commitments as potentially indefinite or lifelong. Sometimes they're not. Sometimes people are detained for shorter periods of time. But the statute authorizes lifetime commitment the way it does for sexually dangerous persons as well. Those persons may not be held for their lives, but they might be. And so that's a significant deprivation of liberty that's very different from the deprivation of liberty affected by Section 35. And I think Your Honors are correct to point out that there cannot be another a renewal of the Section 35 petition. It might be that later along the line another petition is filed, but then there's
This could be, the prior commitment under Section 35 could have an adverse consequence for the second.
there'd have to be evidence presented of the prior commitment, and I'm not familiar with the ins and outs of how that evidence would get in. I suppose the petitioner would have to introduce it to the court. And I'd like to, that goes to another point. The burden is on the petitioner in this case. It's not on the clinician. The clinician is a neutral party.
Can the petitioner withdraw the complaint, withdraw the petition?
I don't believe the petitioner can withdraw
So
it.
at some point, it just becomes out of the petitioner's control.
Yes, but the petitioner is the one that affirmatively comes to court, and the respondent is evaluated by the court clinician, who's a neutral party. And then if a commitment order is issued or not issued, the appellant would be either the petitioner or the respondent. The court clinician is not the party that would appeal the judge's decision to issue an order of commitment or not.
Can I ask you about the evidence? GP argues that both as a matter of procedural due process and as the words of the statute about competent testimony or something, that the rules of evidence should apply, the formal rules of evidence, and you obviously don't. And so what do you say about the statute talking about it's competent evidence or competent testimony?
I believe it's competent evidence. I think as the Chief
Because
Justice...
competent evidence doesn't usually mean hearsay.
I think as the Chief Justice recognized, Section 35 petitions are really unique. They're conducted more or less on an emergency basis. The legislature twice said in the statute that they must be held immediately upon the filing of a petition.
But the legislature used that term. We didn't make it up.
Right, but I don't think competence necessarily means all rules of evidence must apply. So the question is, what did the legislature intend these hearings to look like? And I think looking at the emergency nature of the hearings and also the fact that the types of petitioners that come to court and seek to have their loved ones committed for treatment are laypersons. They're not lawyers trained in the rules of evidence. They're not usually able to understand how to make objections or respond to objections. And given that unique context, which is analogous to Chapter 209A hearings, I don't think the legislature would have intended competent to mean all rules of evidence must apply.
Not really comparable to a 209A hearing. There is no liberty deprivation in 209A hearing.
The liberty deprivation is not as...
Just stepping back from the context from this, as just described, I mean, somebody comes and basically hoists this person into court without any preparation, and there they are, and they face a loss of up to 90 days of their liberty with no warning, no chance to prepare, no lawyer. Some protections seem compelled in those circumstances to make sure that just by being a drug addict, you're not going to be committed.
I agree, Your Honor, that some protections are compelled, and the statute does guarantee the respondent the right to counsel. And the rules...
How would you get counsel if you have to get somebody there right away to complete the hearing by that day. I don't really understand how this works.
I think oftentimes the respondents are indigent, and so counsel is appointed by the court.
Counsel's just available there in order to do it that day?
Yes. I think there's often someone from CPCS there who can handle Section 35 petitions. But
Should the hearing be something akin to a violation of probation hearing in terms of the evidence? Should the evidence be, I think the term is inherently reliable?
I think the rules recognize that the due process requires reliable and accurate determinations, and so they provide a number of procedural safeguards that are designed to ensure that reliable and accurate determinations are reached. So the statute doesn't require a right to cross-examination, but the rules do require that the respondent gets the right to cross-examination. The respondent also is given the right under the rules to present testimonial and non-testimonial evidence. The respondent can testify, the respondent can present expert evidence, and the respondent can call his or her own witnesses.
Can the hearing be postponed in order to allow for an expert to become available? I don't understand. Is the expert also just sitting in the courtroom all the time?
I think as a practical matter, the statute doesn't address whether a hearing could be postponed. I think as a practical matter, it's very unlikely that a judge would do so because there's no provision for holding the respondent overnight. If the respondent poses a substantial risk of harm to themselves or others, a judge would be taking a very big risk in postponing the hearing overnight and
How is a
releasing the
person
respondent.
supposed to get an expert?
As a practical matter, not many of these cases involve experts, but I think the statute anticipates that perhaps the person has been in treatment and is working with a sponsor. Perhaps they could call the sponsor and the sponsor could come testify, something along those lines. As a practical matter, expert evidence is not often introduced.
And if they refuse to talk to the clinician makes that point to the judge? He refused to talk to me, and so what kind of evidence goes forward then?
The rules specifically prohibit the judge from drawing an adverse inference from the respondent's refusal to talk to the clinician, but the clinician could testify based on the intake form or sometimes the petitioner or other interested parties meet with a clinician as happened in this case. The other thing I'd like to emphasize is that the rules specifically state that if the judge is to rely on hearsay evidence, the judge has to make a finding that it's substantially reliable. And that makes this case similar to the Frazato case, which dealt with Chapter 209A hearings. This court said that the rules of evidence need not apply so long as the hearsay is substantially reliable. The defendant is given the right to cross-examine witnesses and present evidence and testify. And the rules ensure that Section 35 respondents are given all of those procedural safeguards, which are very important. We recognize that there's a strong liberty interest at stake
If I could turn to the facts of this case, I mean, I know that one of the concerns that is the constitutional issue as to the standard, but this case also presents a second concern, which is that whether or not the practical application of this is going to be simply to determine whether or not a person is a drug addict, often a heroin addict, as opposed to that second prong of whether the person is a danger to himself or herself or others. In this particular case, I know the appellate division appeared to consider the sufficiency of the evidence, but the judge's ruling, I only have a portion of it in page 4, is everything you say, which I accept, indicates she tried and she can't do it on her own, so I'm going to order her committed. Is that sufficient, that she has been unable to beat her habit and therefore that by itself is sufficient? I would seem to be only the first prong.
Your Honor, the district court isn't taking a position in this case on whether the standard was met. So I think that the district court is certain that both prongs must be met in every case. You have to find that the person is a substance abuser or alcoholic as the statute defines, and that there's a likelihood of serious harm. I think this case involved evidence of that, but we're not taking a position on whether the burden was met.
On that point, does the record indicate, is there some references to, not what the judge said, but what I think what the mother testified to, and was there any reference, any indication in the evidence as to when the events that she was describing happened?
The intake form, I don't believe, gave specific dates. I think there was some testimony that she had pushed and shoved her mother 3 days earlier. And I just like that the mother didn't actually testify in this case. The evidence came in through the intake form. And I believe that was all that came in on timing.
So what's your view on the imminence question?
Right. So I have several points I'd like to make on that. First, as a statutory construction matter, there's nothing in Section 35 or Section 1 that includes an imminence requirement. GP's amici suggests that this court should read an imminence requirement into Section 1 through the terms threat and attempt, but those terms only appear in the first prong of the 3 prongs of the definition of likelihood of serious harm.
But doesn't it use the substantial likelihood, which goes back to a different definition?
The term likelihood of serious harm is in Section 35, and then it's defined in Section 1. And then Section 1 lists 3 different sort of alternative definitions for what constitutes likelihood of serious harm. But the first prong, which involves harm to oneself, has the words threat and attempt. I don't think that those words suggest that there's an imminence requirement, and even if they did, it would make no sense to impose an imminence requirement only in the first prong and not the second 2. So I'd suggest that this court should do like it did in Rosenberg, which is to recognize that as a statutory construction matter, imminence is not required.
But it's not irrelevant.
No.
I don't think it's irrelevant. In fact, it's often an important factor.
I mean, it's only a 90-day commitment, so.
Right, and certainly we wouldn't suggest that the harm could be more than 90 days after the hearing. I think it's often a very important factor, but it's not statutorily compelled, and I'd also like to mention it's not compelled by due
Taking that
process.
point, are you saying imminence is not required, or we should understand imminence effectively to be within the next 90 days?
We're saying as a constitutional matter and as a statutory matter, it's not required. As a practical matter, it wouldn't make any sense for a judge to order someone committed if the judge made a finding that the likely harm was to happen a year from now, because the commitment would be over at that time. I'd just like to, well, I see my time is
If you have
is
one
up.
more point, like we gave it to her, we'll give one to you.
I'd just like to say as a due process matter, I don't think this court should read an imminence requirement into the statute because in Nassar, the imminence requirement was expressly linked to the higher standard of proof beyond a reasonable doubt, and we contend that the standard of proof here should be clear and convincing evidence, and there's no imminence requirement that ought to be linked. Thank you, Your Honors.
All right, thank you. And we'll take our break.
All right.